Today's topic is the judicial branch and the court system, and so our goals for the day are to explain the differences between a criminal court and a civil court system, to explain the trial process, including the rights of the defendant found in the Constitution, and to explain the exclusionary rule. So first of all, you read the case of the shipwrecked sailor, the case of the unclear law, and essentially what this is an example of what it means to interpret the law. Sure, in the case of the shipwrecked sailor, the law was clear. Anybody who deliberately takes the life of another is guilty of murder. But as we discussed, we didn't all necessarily agree on the fact what the punishment should be for the person. I mean, clearly the sailors deliberately took the life of another person, but some of us said, well, they wouldn't have done it under normal circumstances. And so this kind of decision making is what we would call interpreting the law. Same thing with the case of the unclear law. The sign said no vehicles in the park, but does that mean something parked like a tank? And not necessarily for military purposes, but to serve as a memorial to veterans. Again, this is where interpreting the law comes in. And so the whole point of interpreting the Constitution is the job of the judicial branch. We know that a strict constructionist would usually practice judicial restraint, which means a strict constructionist believes in the Constitution exactly how it's written. There shouldn't be any additions, there shouldn't be anything added to or taken away from the Constitution. The Constitution means what the Constitution means. The Constitution is what it is exactly as it's written. The judicial power does not include a right to change the Constitution. A strict constructionist would believe in the Constitution exactly as it's written. Of course, a liberal constructionist practices what we would call judicial activism. And what we usually mean by an activist court is a willingness to interpret the Constitution, a willingness to say, well, the document was written 200 years ago and things have changed and meanings have changed. And so anytime somebody is a liberal constructionist, they practice judicial activism, which means they are willing to interpret the Constitution. This is a current look at where the Supreme Court falls on, the current Supreme Court, where they fall on the political continuum and their willingness to change and how conservative or liberal they are. You can see every justice falls somewhere on the political continuum, but they're not all in the same place. So again, if we talk about the three branches of government, we know Article 1 sets up the legislative, Article 2 sets up the executive, legislative branch makes the laws, executive enforces the laws. It's the job of the judicial branch, Article 3, to interpret the laws. So that's going to be our focus for today. So if we look at the Constitution, Article 3 gives us the right to interpret the laws and also to settle disputes and conflicts. So if people disagree on something, it's the job of the court system to kind of settle that disagreement. Instead of the good old days of fighting things out mano a mano and fight to the death or have a duel, we let the court system resolve our conflicts. And so if we look at the judicial branch, their job is to solve our conflicts. Our current judicial branch and our current system is what we would call an adversarial system. And what we mean by adversarial is that you have the right to face your opponent. This is not something that's secretive, it's not behind closed doors, very out and very open and in the public. You have the right to face your opponent in front of an impartial jury. And what we mean by impartial is somebody who has no biases, somebody who has no prior knowledge or bias of the case. And so generally speaking, my best friend couldn't be on the jury if the case is against me. We want people who aren't going to come in with any preconceived notions. We want everybody on the jury to be willing to make a free and fair decision. So there are a number of purposes of the judicial branch. Number one, we've already talked about it, to resolve conflict. So if we have disagreements, court system helps solve it. The court system is also there to help deter conflict, hopefully with the threat of possibly going to court. People will just try to solve their problems even before getting there. To help communities achieve their goals. Every community has a different goal. These are usually set out in the laws that they have, and so judicial branch helps interpret what those laws mean. Respect the will of the majority while protecting the rights of the minority. We talked about this as a core democratic value before. We said that, look, in America it's a majority rule system, but even if you're not in the majority, even if you're not with the largest group of people, you still have rights that have to be protected. So for example, if we look at the 1880s in the United States, most of the people in the Deep South, the majority, wanted to keep slavery. However, the Constitution protected the rights of the minority, protected the rights of African Americans to not be slaves at the time. And so rights of the minority are protected. Another goal of the judicial branch is to promote order and stability. So to try to keep things stable in our system. It's not good when people have lots of disagreements and when those disagreements tear apart our country. So hopefully the judicial branch will help settle those disagreements. And then finally, to promote freedom and fairness. Fair does not mean equality. It doesn't mean everybody's equal or the same, but to make fair decisions on the laws. So America is kind of weird. We have what is called a dual court system, and a lot of times when you go to the two different types of courts in America, you're going to the exact same building. It's the same judge, it's the same juries, but the jobs within the court system are a little bit different. So we have what are known as civil courts and criminal courts. A civil court is there to settle disputes between private citizens. So if I were playing baseball and I hit a baseball and it broke the window of your car, if you just wanted your money back from me, if you just wanted me to pay for your broken window, you would sue me in civil court. I'm not going to jail because of it, because I broke your window. Just if we want to settle a dispute between private citizens, we would go to civil court. And usually this is also in the same building as a criminal court. A criminal court implies that some type of law has been broken. So if I have done something wrong, but not just something to wrong you, like accidentally hit a baseball into your window, but maybe if I took my baseball bat and I walked up to you and I clubbed you in the knee, that would be a criminal offense. That would be assault and battery. And so as a result, the state is what is considered a party. It means that I have broken a law of the state, and the state will come after me, or the federal government will come after me. And usually in a criminal case, we're talking about jail time or some type of fines or some other type of offense. It's not me paying you back for the damages that I've done. It's me paying back society for the damages that I have done. And so your book has a handy dandy chart that shows the difference between a civil and a criminal court. So we're going to go through a number of different steps of civil courts versus criminal courts. In a civil court, it is always a plaintiff versus a defendant, which just means two individuals facing off against each other. If two neighbors have a dispute, or if two parents are getting a divorce, they haven't broken a law, they haven't violated any act of the Constitution, they just need the court to settle their dispute. And so that would be done in a civil court. In a civil court, if you are accused of something, you must testify in the court. There is no such thing as pleading the Fifth or pleading the Fifth Amendment. That only happens in criminal court. In a civil court, if you are called to stand to testify, even if you could incriminate yourself, you have to go to the stand. In a civil court, the burden of proof, which means how much evidence do we need to find you responsible, is what we would call a preponderance of the evidence. A preponderance of the evidence is a legal term meaning more likely that you did it than you didn't. So in the case of me hitting a baseball and breaking your window, a preponderance of evidence doesn't mean we have to be 100% sure or even 99% sure. We just have to be about 51% sure that I did it. In a civil court, you're not being found guilty or not guilty. There's no guilt. It's either are you responsible or are you not. And so in a civil court, the court is going to rule in favor of one person or another. Either I am responsible for breaking your window or I am not. It's not a matter of guilty or not guilty. I'm not going to jail for breaking the window while accidentally playing baseball. It's just either I'm responsible for it and I have to pay you back, or I'm not. In a civil court, the penalties are not going to jail. You're not going to go to jail. You're just going to be sued. You're just going to have to pay some type of restitution, or you're going to have to give some type of compensation to somebody. So in the case of me breaking your window while accidentally playing baseball, I'm not going to jail for that. I would just have to pay you the $500 to get a new window. Criminal court cases are much different. In a criminal court, it is always the government, or the prosecution as sometimes they're called, versus the defendant. versus the person who is accused of the crime. In the case of a criminal court, it's not person to person, it's the government versus a person. So the government will take the side of the victim. And one of the reasons for this is sometimes the victims choose not to speak for themselves. And sometimes, unfortunately, especially in murder cases, a victim is not around to sue somebody on behalf of the other. And so it is the government versus the defendant. In a criminal court, if you are the defendant, if you are accused of a crime, you have your Fifth Amendment rights. You have the right to plead the Fifth, which means you don't have to testify against yourself. You don't have to take the stand. You don't have to testify against yourself. In a criminal court, the amount of evidence that we need is significantly more than in a civil court. In a civil court, we talked about preponderance of the evidence, roughly 51%. In a criminal court, the burden of proof, how much evidence we need, is what we would call beyond a reasonable doubt. And what that means is if you are a, quote, reasonable person, if you have any doubt in your mind, you must find the person not guilty. Now, that doesn't mean they're innocent. It just means there wasn't enough evidence to find them guilty. In a criminal system, you are innocent until proven guilty. This is a big part of the criminal system in the United States. So again, if we talk about preponderance of the evidence, you got to be about 51%. In reasonable doubt, you have to be pretty darn sure. And generally, we think of this as about 98, 99% sure. There can be no doubt in your mind. In a criminal court, the ultimate decision of the jury or the judge is guilty or not guilty. Now, that doesn't mean that you didn't do it. It doesn't mean that you are free. It is guilty or not guilty based on the evidence that we have. And if you're found not guilty, you are acquitted. It doesn't mean you didn't do it. It just means the court didn't have enough evidence to prove that you did it. In a criminal decision, the jury must be unanimous. That means every juror must agree. Every juror, and usually there are 12 jurors on a jury, all 12 jurors must agree. If they don't, then this is what is considered a hung jury. So if 11 of them think that you're guilty, but one of them thinks that you're not, it would be considered a hung jury. And whenever we have a hung jury, whenever the jury can't come to a conclusion, they declare a mistrial. Now again, a mistrial doesn't mean you're guilty, doesn't mean you're not guilty, it doesn't mean you're innocent, it doesn't mean anything, it just means there wasn't enough evidence to get the jury to agree. So technically, we know that you can't be tried for the same crime twice, but if a mistrial happens, if the jury disagrees, then you will have another trial because there has not been an actual ruling in your original trial. So you could go on trial several times if each time they get a hung jury. In a criminal trial, the penalty is much stiffer than in a civil trial. In a civil case, you just have to pay restitution to the offended party. In a criminal trial, potential penalties include jail time, fines, sometimes you have to pay a fine, probation, which means you have to check in with an officer of the court from time to time, but you do get to go free. Sometimes you'll have to do community service, so you see those people on the side of the road picking up trash. That's the most common form of community service. Sometimes something as strict as the death penalty could be a result from what you have. These are all various different things that you could get as a result of being found guilty in a criminal case. Trial process. So how does a trial work? In a criminal case, or even in a civil case, I guess, if the police are going to search your stuff, they have to have a warrant or they have to have probable cause. And again, we've talked about probable cause, slightly less than preponderance of an evidence. You still have to have a lot of facts to lead an ordinary person to believe that you've got something to hide. Just because I have a hunch, that's not probable cause. But if there's a little bit of evidence there, we don't have to be certain, we don't have to be sure. But if we can kind of believe like maybe there's something there, that gives us probable cause. So for example, if I'm a cop and I pull you over and I smell marijuana, I don't see you smoking anything, but if I smell marijuana, that's probably probable cause. That leads an ordinary person to believe that there's something to hide, in which case the cops have the right to search your stuff. If there is reasonable belief that a crime has been committed, the police have the right to make an arrest. Now, an arrest doesn't mean you're guilty. It doesn't mean you're going to jail. It just means they have the right to detain you, and they have the right to, when they detain you, conduct a personal search. Now, there are some circumstances in which you don't need a search warrant to search somebody. You're not going to have to memorize these, but people always ask, and so if you want more detail, take the legal systems class that we offer, take the practical law class that we offer here. But generally speaking, these are some examples of when you don't need a warrant. Number one, if you have the consent of the person being searched. If I say, can I search you? And you say yes, then I don't need a warrant. Number two, if I have probable cause. Again, if a reasonable person believes that you may have done something wrong, the cops have a right to search you. Number three, in plain view. If I can see something illegal, I've got the right to search. An incident to arrest. What that means is if you're being arrested, the cops have the right to search you, and if they find something even unrelated to what they're arresting you for, they have the right to do it. If the cops are in hot pursuit or if they have exigent circumstances, what that means is if you're running away and there's a likelihood that you'll destroy the evidence, they can search without a warrant. In certain cases, the cops have the right to stop and frisk. I'm not going to get into those. Ask a police officer. They'd be happy to tell you when they can and can't do that. At a border crossing, you have no rights at a border crossing. The cops can search you without a warrant for any reason. Whenever your parents give permission, so if you're in custody of the court or custody of your parents, the cops don't need a warrant. If there's an emergency situation, so say police department or fire department breaks into your house because your house is on fire and they find something illegal in there, they have the right to use that against you. If you abandon your property, which means even trash on the side of the road, they have a right to search. And if you are on probation, the cops have a right to search you for any reason. And finally, administrative or regulation of a business. So if for some reason an agent of the government was going to a business to say check out the health code and they happen to find something else there, then the cops can search without a warrant. If you don't have a warrant or you don't have probable cause or something is not in plain view, then the courts do not have the right to search your stuff. If they do, any evidence that's found falls under what is called the exclusionary rule. So if you don't give permission or those 12 circumstances we just talked about don't happen, if the cops find something and they don't have a warrant and they haven't met any of those conditions, then the evidence becomes what is called tainted, which means it was illegally obtained. And if evidence is illegally obtained, then it cannot be used against you in the court of law. And this is what we call the exclusionary rule. It means any evidence that is illegally found must be excluded from the court. That can't be used against you. Other rights you have under the Fifth Amendment, you've got the right to due process. So you have protection against double jeopardy, being tried for the same crime twice, same incident of the same crime twice. You have protection against self-incrimination. That is, you don't have to take the stand to testify against yourself. You have the right against cruel and unusual punishment, so the court cannot torture you in any way. If you are accused of a crime, this is generally the process that would be followed. Number one, you would be indicted, which means that you are formally accused by the court. Number two is the booking stage. That means the cops go out, they arrest you, they take you into custody. The third stage is what is called a pretrial release. That's where bail is set. What that means is if you're not a flight risk, if they don't think you're going to run away, if they believe that you're going to come back for your trial, the judge will usually set what is called a bail. What that means is you give money to the court system as a way of securing and ensuring that you come back. And as long as you come back, you get your money back. So if the court lets you out on $100,000 bail, you would have to give $100,000 to the court system, but as long as you come back for your trial, you get your money back, even if you're found guilty. Step number 4 is the arraignment process. What that means is they bring you before a judge and ask you to make a plea. So you either say that you're guilty or not guilty, or sometimes you can plead what's called no contest, nolo contendere, which means you're not guilty, you're not guilty, you're just not willing to fight it. The next stage is a preliminary hearing. After the arraignment, they decide, does the court have enough evidence to proceed? Do they have enough evidence to take you to trial? At this point, you could sometimes reach a plea bargain, which is a special deal with the court. If you agree that you're going to plead guilty or no contest, because they'll save the time of a trial, because they won't have to go through all the money and resources of actually putting you on trial, usually you get a lighter sentence out of a plea bargain. Step number 6 is the actual trial, and then after your trial, if you are found guilty, the sentencing. So what your punishment will be. This is another way of looking at essentially the same system from arrest all the way to the actual trial. That's all for today. I hope you have a wonderful day and take care.